they're not thinking about it and how to protect themselves from it, they're probably going to be deep into it within a certain amount of time. And today, Mark, I think you have an interesting topic to talk to our listeners about.
Nice to be with you, Jeffrey. Wanted to talk about a case decided by the Supreme Judicial Court in Massachusetts. It involves the question of when claims survive the death of a party. So, it's unclear to me why this rule has existed for hundreds of years, but the old rule has always been that tort claims don't survive death. Contract claims do. So, and it affects whether the plaintiff dies and the estate loses the claim or gets to keep it, or whether the defendant dies, in which case the case gets dismissed. So, so you have this broad principle. It's been changed a little bit by the legislature, but you still have cases that involve the question. So here's a case where a company, could be one of your folks listening here, supplied goods to another company and didn't get fully paid. So they brought suit against the defendant company and obtained a judgment for, call it a couple of $100,000. Well, the defendant didn't pay. And so the plaintiff then decided to bring a claim against the owner of the defendant company. Now, everybody thinks that if you have a company, you can never be sued individually. That's wrong. It is the case that the corporate shell protects you from contractual obligations, but it doesn't protect you from tort obligations. If you're driving a company car and you run someone over and you're responsible for the injury, you can be sued personally, even though you're working for the company, driving a company car. So the protection is partial, it's not complete. So in this case, the plaintiff claimed that the defendant who died had engaged in certain fraudulent conduct. The claim was that he had transferred assets to another company without fair consideration, call it a fraudulent transfer allegation, that he had made misrepresentations, call it a fraud claim. And so suit got brought against the estate, claiming that the estate was liable for all of these actions. The defendant the estate moved to dismiss, and the Superior Court dismissed the case. The Superior Court ruled that all of the claims were claims premised on the theory that the decedent had engaged in fraudulent conduct. Therefore, they were tort claims, not contract claims, and therefore the Superior Court threw out the whole case. The plaintiff appealed, the Supreme Judicial Court grabbed the case and recently reversed. They said that the fact that there was a contract between the plaintiff corporation and the defendant corporation was sufficient to allow the claim to survive. And included in the claims was a 93A claim. And the 93A claim was determined on the allegations to survive as well. However, a majority of the court decided that the triple damages component of 93A was barred by the death of the defendant. So it's an important case on survival, and it shows how these disputes can arise. So folks, when you're in this case, the defendant's attorney was arguing that everything was tort related. The plaintiff's lawyer was arguing everything was contract related. So, so tips. Well, I think the biggest tip is, if you're supplying material, you ought to think about whether or not the party that you're supplying the material to is creditworthy. And there are ways to protect yourself. You know,
Such as,
you take a credit application.
right?
And some credit applications contain personal guarantees for good supply. If it's not in there, you're not going to get it. Some credit applications provide attorney's fees. If it's not in there, you're not going to get it. You know, if you're the supplier, your greatest leverage point is at the point where the defendant, the purchaser needs the goods, provided you're in a good bargaining position. If it's a commodity situation where they can get it from 5 other folks, if you don't want to give it to them, you don't have the power to get personal guarantees, attorney's fees clauses. But I think it's worth thinking about because the last thing you need is litigation. You need encouragement for the purchaser to pay you. And the last thing anybody wants is to have a case in the Supreme Court and all that's involved in that.